All right, Randy Manning here, managing partner of Ramos Law, and I'm with our consumer protection attorney, Matt Osborne. Matt's probably tried more cases than anybody in the state in the last 2 years, and we're going to break down Peters versus American Pacific. Hey, Matt, why don't you give us a little bit of an idea of what a consumer protection case and then what this specific case was about?
Okay, so consumer protection can mean a lot of different things, but it's false credit reporting, fraudulent bank charges, identity theft, where the bank doesn't want to believe you, landlord-tenant problems, bad faith insurance, all kinds of stuff. So this particular case, Justin Peters was in the Air Force Reserves, and he had a mortgage with American Pacific Mortgage. And basically, they took one of his payments and they misapplied it to something that they shouldn't have. And so it threw his whole loan out of whack. So he called them to complain. They tell him on the phone, all right, hold off on making any payments until we fix this error internally, and then we'll tell you when to start making payments again. So he does this, and then they reported him as late. And so then he calls them repeatedly to complain, and they tell him, we're sorry, we messed up. We're going to ask the credit bureaus to remove the late payments. For some reason, they never do. So then we sue, and I think it was 2 days after we sued, they had an internal email where they said, we messed this up, we need to fix this, get this fixed right away. And then they fixed it after we sued them. And so then their defense was kind of like, okay, it's now fixed. Why are we still doing this case? Go away. This guy doesn't have any damages. And they also said, by the way, we never told you that. And it was accurate all along. You should have been reported as late. So that was kind of the way it was set up.
Okay, well, that's interesting. So they said, hey, we should have reported you as late, but then there was also internal communication saying, we screwed this up.
Right.
And what were the damages? You say they're saying he has no damages. What are the damages in these types of cases?
Yeah, so we had no economics, which is fairly common. They're usually going to be non-economics and punitives possibly. So he was denied credit for a home remodel, and he was denied credit for an engagement ring for his fiance. And so that was the basic damages going into it, along with just general stress and frustration of going through the whole dispute process and getting the runaround for months on end.
So personal injury attorneys, it's a big deal for them to blackboard damages or whatever they say, those buzzwords, where we're going to put up this amount in bills and this amount in wage loss. How does it feel going into a trial where you really don't have any of that?
Yeah, it's a little bit different because in most consumer cases, you either have no economics at all, or your economics, if you do have them, are so small that we usually waive them so that it's not a low anchor for the jury. So usually you're going in with pure non-economics, and you're basically just throwing a number out for the jury and hoping they'll go along with it.
Does that affect your trial strategy in these cases where it's not like, when we're doing a trial, it's like, hey, they have $100,000 in bills. If you don't give them any money, they're not gonna even get back to even in this case. How do you start the process of like selling a jury on a large non-economic award when there's nothing out of pocket?
Well, we usually start testing that in voir dire and figuring out, could somebody even be comfortable with that process? And how can you award damages if you can't even see them? and just testing how people feel about that. But, you know, sometimes even people that resist that in voir dire tend to be our biggest jurors or our best jurors. Like in this particular case, the lady that became the foreperson told us in voir dire she thinks emotional damages are fabricated. They should have to be proven beyond a reasonable doubt. And, you know, she's going to hold us to a very high burden. I was going to strike her, and my co-counsel said, I've got a good feeling about her. I was like, all right, let's leave her on then. And so we left her on, and she turned out to be our best juror. So,
what do you think you did throughout the trial to overcome that bias, or that, you know, her obvious bias that non-economics are made up, or whatever it is she believed?
I think the biggest thing is you need to be able to tell a really good story. So it's similar to a PI case in that way. You need a story that people can connect with, and that people can relate to. And if they believe your client's telling the truth, they'll usually overcome whatever biases they have and give you something fair, in my experience.
So I've always subscribed to the idea that, you know, you kind of need to know what drives your damages in a case. And I think the two most likely paths are going to be the plaintiff story is very compelling, and there's a lot of, you know, emotion the juror feels or identifies with your plaintiff. Alternatively, you have, you know, the defendant's conduct was really bad, and the jury feels justice must be done. Was there a stream, or did you see those kind of themes in this case?
Yeah. I've always felt if you have a really likable plaintiff and a defense who says we didn't do anything wrong, those two combinations usually go well. And so, yeah, we had that in this case where they basically showed up and they said, why are we even here? Why did they file this case? This is a stupid case. They were kind of talking out of both sides of their mouth, where they were saying, well, it really was accurate. But then they had all this internal communications where they said it was inaccurate. And then they actually certified to the credit bureaus that it was inaccurate. So, like, they kept waffling on their positions, which helped. And then they sent somebody to testify as the corporate rep that wasn't even involved in the case. It wasn't even her area. She didn't even know anything about credit reporting or how it works. So that was good. And then they also had a guy that was like, that was supposed to know all the answers. And before I would ask a question, and he would pause for like 30, 40 seconds before he'd answer it. So I'd say, sir, it's true, your company, they didn't even read these dispute letters, did they? And he would just, instead of just answering it, he would go, then he'd start flipping through the exhibits, and he'd start looking around all nervous. And everybody on the jury they told me afterwards, they just assumed he was lying because just his body language was so bad. And then he would go, no. And like, everybody was like, what is this guy talking about? And he did that for like an hour.
Oh, geez.
Yeah. So that played really well for us too.
Yeah. And so on a case like this, I mean, you know, I guess there is, we messed around with the guy's credit a little bit, you know what I mean? Couple of administrative headaches he had. You know, maybe we'll give you a couple of bucks to go away. What was the offer that they made?
Yeah, so it was actually the Friday before trial. They had offered, I think, like $10,000. And I mean, by that time, we already had, you know, well into the six figures in attorney's fees. They had filed multiple motions to dismiss, and we had done deposition, summary judgment, discovery, mediation. And so we couldn't take that. We had to try the case, you know.
And attorney's fees are collectible in this specific action.
Yeah. So if you win, then you get reasonable attorney's fees in most consumer cases.
Okay. And this one was the same.
Yeah.
Is it what claims? Just what were the cause of actions that you pled?
So we had Fair Credit Reporting Act, and the violation is either going to be negligent or it's going to be willful or both. So we always plead both, and willful is basically a reckless disregard standard.
And how did you stay out of, this was in state court. How did you, this seems like it could have gotten removed. Am I wrong?
Yeah, it definitely could have gotten removed. We filed it in Larimer because that's where the property was and that's where all the facts happened. The defense could have removed it, but they chose not to. And I'm not sure it would have ultimately mattered, but the only thing that, you know, state court tends to move faster, generally.
Yeah. So you're in state court, Larimer County. And then what were, my understanding is there was this kind of pivotal moment with a visor that happened in the middle of trial.
Yeah. Yeah. So we had a witness from that lived in Pennsylvania that had crucial testimony. Obviously, we can't subpoena her to trial. So we had to play about 10 minutes of her deposition to basically survive directed verdict on a certain element. And the defense in front of the jury objects and says, Judge, this shouldn't be allowed because this was a Zoom deposition and Mr. Osborne was sharing his screen while he was asking this witness questions, showing her documents, and those documents have yet to be admitted into evidence. And so I said, well, I have a solution. We can cover up the documents, and then the jury will just see this person's face up on the TV. And the defense is like, okay, yeah, that's fine. So I tell Mike, I need you to find me like,
Who's Mike real quick?
Mike is my all-star paralegal that's been with me for 10 years and has sat through all my trials and has a really good feel for what jurors are thinking and what they want to know. And really, really awesome guy. So I tell him, I'm like, run back to the hotel real quick, find me like a blanket or a comforter or something to do this. So he comes back and he's like, all I can find is this big giant Chewbacca sun visor for like his big SUV. So this thing's like 5-6 feet wide. So
It's got Chewbacca on it.
yeah, it just has a big picture of Chewbacca. So I said, you know, Your Honor, can we go ahead and play the video now? And he's like, sure. So nobody knows I'm going to do the Chewbacca thing. And so I just like take out this big giant Chewbacca and I'm like covering up the documents. And everybody on the jury is just looking at me like trying not to laugh. And they definitely came away with the impression that the defense was trying to hide something because they were so vocal about, you know, don't let the jury see this, you know.
Were they saying that in front of the jury, or was the judge having you come and do a bench kind of conference?
They kind of did a little of both. So, like, we had the main discussion with the judge, but they definitely made the objection in front of the jury. And then at one point when I was holding it up, I looked at the defense counsel and I said, you know, my arms are getting tired. Can I put this down? And he goes, no, not yet, Mr. Osborne. Everybody on the jury is just laughing, like, what is going on here? So that was pretty funny.
Well, that's an interesting practice pointer. I mean, if you're going to say we shouldn't put this evidence in front of the jury, I don't think that it's typically the right decision to say that in front of the jury.
Yeah, usually not. And I don't think they didn't think about that until after. I think they started to realize, like, as it was coming in, how bad they looked. Plus, they had several of their own documents that they just unilaterally redacted without explaining anything. So a lot of people were just like, what is this company trying to hide, you know?
And they didn't even object to the Chewbacca. Did they try, like, I think I would have been like, Judge, we can't, this is silly. You know what I mean? This is a courthouse. We got, you know, Buddy's cartoon characters coming up here. You know what I mean?
Yeah, they didn't object. I don't even know what the objection would have been because they already agreed to having it covered up. So, and they were kind of just shocked. Like they definitely were not anticipating that, to say the least.
So you're getting into closing, you know, your client, you know, couldn't afford a wedding ring or an engagement ring. You know, he can't, he's having a hard time remodeling his house. What are you going in to ask for?
Yeah, so we asked for 1.8 million, and we actually started asking for that in voir dire. And just said, hey, could you ever award 1.8 million for false credit reporting? And we were expecting a lot of people to say no, and most people said, just depends on the evidence. Maybe it's not enough. Maybe we need to award more. And so, yeah, that's what we asked for, and then they came back with 800,000.
Wow. And you, no economic damages claim, just that was pure non-economic.
Right.
Is that capped?
No, it's not. There's no federal cap.
Okay.
And since it's under federal law, you have to follow the federal statutes. But it's subject to the normal rules on, you know, excessive damages and remitted and all of that stuff. But yeah, there's no strict cap like in state court.
So you win 800,000 attorney's fees, costs, I'm assuming, and then prejudgment interest still?
That's right, yeah.
Okay. And well, that's a big win.
Yeah, it was, the defense was shocked because, I mean, they had offered 10,000 and never in a million years did they think they were going to get hit with something like that. I mean, they stormed out of the courtroom and yeah, they were not happy.
And then they, of course, they do what they do and they go back and they start writing all this stuff. You know, let's be professional. Let's be, you know, we can't really trust the jury, right?
Mm-hmm.
As that was pretty much what their arguments were, and the judge ended up buying into some of them.
Well, they filed a post motion for remitted, where they just said like, hey, this is the biggest non-economic award on an FCRA case ever in America. And they weren't wrong about that. I think the next biggest one they could find at the time was like 250,000. We've since beaten that in other cases, but the judge basically said, okay, I'm going to reduce this down to 250. So plaintiff, you can either accept a remitted of 250 or you can have a new trial. We ended up taking it because, you know, I thought we would win more at a new trial again, but then it would just probably get remitted back again. And we were also kind of thinking like, well, if you do the second trial and let's say you win $10,000, can you then appeal the first one? And it looked pretty questionable. So we decided to just accept that. Then they appealed it, and they basically asked the Court of Appeals to change the $250 to $1. And they obviously rejected that. So the Court of Appeals affirmed the verdict, and now they've petitioned for cert at the Colorado Supreme Court. And they were also trying to get an offset from, because we had also sued the credit bureaus. So they were trying to get a set off for all the settlements that they've paid. And so far the courts have rejected that.
So, but you still got the 250 pain and suffering, or non-economic, the attorney's fees, costs, and interest. I mean, what was your client's reaction? I mean, you couldn't be like, oh, we're going to just go win the biggest FCRA verdict in the history of the United States. you know, so yeah. Like, what was his expectations?
Well, he he didn't really have any. I mean, it was his first lawsuit. He's very easy to deal with and very just kind of deferred to us and just said, I'm following your guys' lead, which is always helpful when a client just defers to your expertise. And so he's been really easy to work with. He was pretty surprised, I think, too, that it turned out to be that much. But yeah, he's just like, well, I'll just follow what you guys tell me, and so it's been really easy to work with.
Well, you truly are a master, Matt. I mean, that's an incredible story. Very, very interesting area of law. And, that'll conclude our time for today. But thank you very much, Matt. And I hope you learned a lot.